Thank you. Good morning.
Morning, Your Honor.
Good morning.
Christina Siffler, Alan Mizrahi, and Steve Siegel on behalf of the state. We're here on Shanna Gardner, number 9 on the court's calendar, and Mario Fernandez, number 4 on the court's calendar.
Thank you.
Good morning, Your Honor.
Good morning.
My name is Jesse Dreiser. I represent Mr. Fernandez, who's present and sitting at council table, along with Ms. Day, Mr. Hill, and Frank Tassoni, who is appearing via Zoom.
All right. Thank you. Good morning.
And Your Honor, for the record, next of kin is present via Zoom as well.
All right. Thank you.
Good morning, Your Honor. Patrick Crody for Shanna Gardner, who's present for the court. Also, Ms. Nelson and Ms. Medina, counsel, are on Zoom.
All right. Thank you. Good morning.
And Your Honor, since our last...
Wait. Ms. Nelson, can you hear us? Ms. Nelson.
Good morning. I
Okay.
apologize. We're unable to hear the proceedings.
Okay. Can you hear me now? It's Mike, can you come up?
Your Honor, I think it may be on her end because we can hear.
Okay.
I'm going to ask Frank if he can hear us.
Mr. Tassoni?
Yes, Your Honor.
Okay.
Frank can hear us.
Mr. Carodi, can you message Ms. Nelson and say that she needs to look at her device? Everyone else can hear.
Yes, Your Honor.
Ms. Medina, can you hear?
Yes, Your Honor.
Okay.
I can.
Okay.
Your Honor, we can proceed.
Okay. All right. So I know that I owe an order on the wiretap, and I just want to clarify. I did deny it, but I just need time to edit. I was in first appearance. I've been in trial. So
That's fine, Your Honor. For the court's information, since our last court date, we have taken a number of depositions. We have depositions, the last remaining ones set for this afternoon. We have depositions for next Friday, the 17th, for Ms. Gardner's listed witnesses. And I think that should conclude the discovery depositions, absent maybe 1 or 2 remaining witnesses.
okay. Does the defense agree?
I think within small numbers or entirely, yes. Meaning there could be a couple that I'm just not thinking of, but we are nearing the end, and it may be that we're done.
Okay. So from Mr. Fernandez, his legal team's perspective, is there anything that we need to do? I indicated that I'm going to go upstairs with the lawyers for logistic purposes, so that I can have, I can answer any questions and also like kind of get an idea of, you know, what you all will need in order to try the case. So
The only thing that I would ask is out of abundance of caution that if the state and I cannot come to an agreement regarding this afternoon's deposition, that we get some hearing time on Monday or a to-be-set, whatever the court's preference is.
I'm going to do it on Monday. I do have 2 jury selections, but I believe one of my colleagues is going to select for the second one. And so I'm going to move my jury selection to 1:30, and then my thought is I can handle these motions that relate mainly to discovery earlier rather than later, so I would handle them at 11 a.m.
All right, so you want defense counsel here at 11?
Correct.
Yes, ma'am. We'll be here. So this upcoming Monday at 11.
Right.
And with-
July 13th at 11 a.m. hearing on motion.
And if this gets resolved, if we could just email your judicial assistant, and then you could just give us another past date that you see fit. I do think there's at least a 50-50 shot that we resolve this by tomorrow.
Okay. If you don't need the time, that's fine. I do want to have a final pretrial. I did not set that initially. I'm a little bit hesitant to do it the week before like I normally do. Do you want 2 weeks before, like the 27th?
Yes.
Yes, and then whatever,
And this is for Mr. Fernandez's case. So his final pretrial will be held July 27th.
and what are you thinking in terms of motions in limine? In terms of like time in between those 2 weeks? I know there's a deadline set because I saw it on my calendar for when they're due, but when were you thinking we would actually hear them?
So you all take priority over anything. That's what the priority order is. So if you need me to handle them, you just let me know and you advance on my calendar. So I'm depending on the parties because you all know the substance of the motions to kind of let me know how much time you need. All you have to do is let me know that and I will advance you on my calendar.
Yes, Your Honor. I'll get with Mr. Dreiser and see what they're going to file, what we're going to file, what we agree upon, and what needs court time.
Right.
Okay, so if you need the time, I'll give you the time. You don't even, all you have to do is ask and I will.
Understood. Thank you.
Okay, but just to be clear, so Mr. Fernandez's case will be passed to July 13th, and it's, let's do it in, do you know, is, Ms. Janako, is 407 available
It should be, yes.
next week?
On the 13th.
Yes, so we'll set it in 407 for hearing time.
Yes, Your Honor.
Okay, 11 a.m.
There was one last issue that we had taken up with the court previously regarding an agreement between the parties as to the testimony of a minor witness, minor victim, BB. The parties have come to an agreement. We're going to put it in writing and file it with the court. And the agreement is that the state is not going to call BB as a witness at trial, so we do not need to have any litigation on competency issues. The defense has agreed to the admission of a video from the scene of the minor child and to waive their confrontation and legal objections to testimony by 2 civilian witnesses as to her statements on scene. I'm going to put that in writing as a stipulation, and the parties will sign and we'll file with the court.
Okay.
We also agreed, we're coming to agreements as to certain witnesses that may appear via Zoom. We have agreed that AB, which is the initials of another minor that we expect to testify in this case, will appear via Zoom.
Will appear?
Will appear via Zoom.
She's a listed witness for the defense. Mr. Dreiser intends to call her. Mr. Carodi has accepted subpoena service from both the state and Mr. Dreiser for AB with the understanding that her guardians would consent to her testimony in Mr. Fernandez's case via Zoom. So we'll sign a stipulation from both state and defense as to Zoom testimony, and Mr. Carodi has accepted those subpoenas.
Okay, so if the stipulation, I want you all to go over, there's a 5th DCA case, I believe. I can send it to you, that you go over that particular case with your clients, Mr. Dreiser with Mr. Fernandez, and the state. I'm going to send the copy to you so this, there's a requirement, if there's an agreement, it's not that big of a deal. However, prior to Zoom testimony, there has to be confirmation that Mr. Fernandez can see the witness can see Mr. Fernandez. That is a main issue, and I don't think that it should necessarily be an issue because of 407 and how it's going to be set up. But all those things have to be confirmed for the record, and then it specifically addressed the confrontation waiver. Okay.
And we should be able to take care of that. She's a defense witness, so I don't think.
She's also listed by the state.
I think the waiver of confrontation will be something we can take care of.
And then having said that,
It was actually in this courtroom. I think Judge Soud wrote, it was an affirmance, but Judge Soud wrote
Yes, sir.
a concurrent opinion that I think gives guidance to any remote technology.
So with that instruction for our future conversations, I just assume that the court, if we had an agreement as to witnesses, you would not necessarily have it.
Yeah,
An
it doesn't, no, it does not matter to me.
You just want us to make sure we run all those people by our clients so that
Right.
you could do a inquiry if need be.
I will do an inquiry. We can do it, just kind of as a group, but I don't want any issues related to what their rights would be. So if you just, it's an easier process if they know kind of what the law is, and then if they want to waive it, they can waive it. I don't have any objection to remote technology. I think it's the wave of the future, but it just has to comply with, meaning, so one of my, I remember substance. I don't necessarily remember names, but I can tell you there are two cases that come to my mind. One is from me, this court, 5th District, a binding appellate court decision. It was an affirmance, but it was instructive how basically the court, one of the judges from the court felt about the confrontation clause. I think it's instructive. Two is that there's another case that comes to my mind. I cannot remember the name, but I will get it to the lawyers, that basically wherever the witness may be, okay, it has to be impressed upon them that this is a court proceeding, that there is seriousness in their testimony, that they understand that the oath, and that they understand that they could be held responsible for any perjured testimony. And so with all of those kind of in mind, when you are setting up your Zoom, when you are setting up your remote, it needs to look professional. They need to know, even if it's a minor child, that this is, an important proceeding, especially on a minor, because, maybe there's a modified oath given, and y'all need to talk about that if you want a modified oath or you want the regular oath, but it needs to be impressed upon them that this is a court proceeding. And so with all of those kind of taken care of and thought about, I don't have any problem with it. You don't ever have to worry that, the judge won't let it. That's not my idea. I just need to make sure that they understand, kind of the seriousness of these proceedings.
And for Mr. Fernandez, I think that covers it, and then we'll wait until we go upstairs.
Okay.
Thank you.
Your Honor, my understanding is that we also have a,
Come on.
oh, I'm sorry, Your Honor. We'll put a microphone in front of me. It was okay this day. Your Honor, my understanding is that we'll also be here Monday at 1100 for a motion.
Yes. So I haven't seen it yet, but I've heard it's been sent to me. I did read the materials by the defense on the subpoena request, and then I haven't read the state's response, so I will do that.
And then with the agreement related to the minor child BB, I believe it would be appropriate for the court to deny our pending motion as moot related to excluding her testimony.
Okay. Could you do a form order for that, Mr. Hathaway?
Yes, Your Honor.
Okay, thank you.
And Your Honor, while Mr. Carodi is here, I wanted to bring up one small issue, and it has to do with the court's order regarding the timing of the filing of the motion in limines.
I can adjust it.
The state's thought process is we're going to be in trial when their deadline is. So I understand there may be things that come up during the Fernandez trial that causes the defense to file a motion in limine.
Tell me what the overlap is.
It's
What's
5 days. It's 5 days before the commencement of each jury selection. The state's thought process is some of the motion in limines will overlap, and as practical as we can make it, I would like the Gardner motion in limines to be filed 5 days before the Fernandez motion in limines. So in other words, we can hear them all at the same time. understanding there may be something that creeps up in the trial that we have to hear, but I don't want to be in this situation where the state's in trial and the defense is filing motions in limine that we have an opportunity to respond to or litigate before the Gardner.
What's the defense position on that? Do you have, I mean, well, let me ask it this way. Are there motions that y'all are contemplating that could be filed ahead of the Fernandez jury selection?
Judge, at this time, I can't tell the court that there are any specific motions. I'm sure there will be. We have relied on the court's order, as to that deadline.
Right.
Mr. Wright, he brought it up to me this morning. I'm just not in a position
Okay.
today to address
Can
it.
you talk about it and we address it on Monday?
Yes, sure.
All of you all are very, very experienced lawyers, so I'm hoping that we're not going to be litigating things that are just accepted law. You know what I mean? It should be related to perceived evidentiary issues that are real. You know what I mean? Not boilerplate.
Yes, Your Honor.
Yes, ma'am, of course.
But I mean, to the extent, it's hard for me to do that because when they're separated in that way,
From the state's perspective, having it 5 days before Fernandez, just like the Fernandez order says, doesn't put an undue burden on the defense to have their motion limines done, 3 weeks before as opposed to 5 days before. I don't think it's that unreasonable. And the same would hold true for the state if we have any in the Gardner case, that we would file it early. I just think if we're going to have motion limine hearings the week of the final trial, we should do both defendants as much as we can. I'm not going to say that they can't raise something up, but we're trying to comply with the court's order. I just didn't want to be inundated with some motion limines while we're in trial. That's what I'm trying to prevent.
Your Honor, I can say first that we'll try and file motions as soon as we know we're going to file them. Second, though, I do respectfully disagree with Mr. Mizrahi. When the trials were severed and they were set, that sort of set our preparation timeline as to how we are preparing. I believe that, the additional 3 weeks that we have, we're working it into trial preparation. So I don't think that we should be held to the same timeline as Mr. Fernandez, who has had ample notice of his deadline for months.
Okay. I'll take a look at it. I'm going to ask the lawyers to take a look at it. Maybe one of the ways to resolve it is you all have been adopting certain motions filed by, Mr. Fernandez's team, and to the extent that it may apply in your trial, maybe that's one way to resolve some of those issues. You see what they file, you can decide whether you adopt it or not, handle it at the same time. But my thought process in setting the deadline the way that it was is that I was kind of told by, you may not take all the time. So there may be time that we are on break or done with the Fernandez trial and we can litigate in the Gardner trial. But obviously I wouldn't put the state in a position where you couldn't be prepared. I wouldn't be unreasonable. So if you did need the time, I'd give it to you. So I don't necessarily think that is a concern, but maybe one of the ways that you can resolve it, you see what Mr. Fernandez's team files, and then you can see if you want, we can have it kind of at the same time, whether you want to adopt or you're going to let that one, it doesn't apply to your case. And then the state can have those rulings, at least the preliminary rulings from the Fernandez case. But my general thought about motions in limine is it's hard sometimes to rule in a vacuum. So some of these things may have to be deferred anyway for proffers and things of that nature. So I don't know what you all are intending, but Mr. Mizrahi, maybe to make you feel better, I would not make you respond to something that you're not prepared for. So,
Thank you, Your Honor.
I just wanted to bring up the issue also.
all right. Have you all met with IT?
Yes, Your Honor.
Okay. Especially if y'all are going to be using Zoom and things like that. Y'all, the defense team, you've met?
The Fernandez team spent a whole morning following your report.
Okay.
We met with everybody from ample Mike, court administration,
Okay.
through all the technology in the court.
Great. All right. Well, so I will see potentially both cases, depending on what y'all's agreement would be, on July 13th, 11 a.m., courtroom 407, hearing on motion.
Thank you, Your Honor.
Yes, Your Honor.
Thank you. All right, court's in recess to set up for the normal calendar.